Attention landlords in Tennessee. If you haven't heard, you need to be aware of and be in compliance with the Tennessee Uniform Residential Landlord and Tenant Act. Hey, my name is John with Rent My Home Property Management here in Clarksville, Tennessee. We manage single family homes and small multifamily properties everywhere from Clarksville, Tennessee, all the way down to Nashville, pretty much an hour's drive from either of those cities. Today, I just want to share with you guys a few fun facts about the Tennessee Uniform Residential Landlord and Tenant Act, or the Landlord and Tenant Act, as I'll sometimes say in this video. I'm just going to go through a few rapid fire facts that you may not have known, but that you should be aware of if you have rental properties in Tennessee. First things first, I'm not a lawyer. I don't play one on TV. Contact your lawyer, yada, yada, yada. I'm just reading straight from the Tennessee Landlord and Tenant Act online. So this law applies to counties with 75,000 people or more. And so the smaller counties generally doesn't apply. This law applies generally to those more populated counties. That's why they have it broken up here. And so first things first, you want to know, okay, if I have a rental property, is it in one of these counties where this law applies? Now, essentially this law is going to tell you how you can run your landlord business. What's acceptable for you as a landlord? What can the tenant do? What can you do as a landlord? What are the rules that everyone has to follow? Now, if you have a lease in place with a tenant, you got to make sure that lease is in compliance with this as well, if you're in one of those counties. First fun fact I'll point out is that this Landlord and Tenant Act actually provides for a 5-day grace period before you can charge a late fee to a tenant for late rent. If your lease says rent is late on the 3rd or the 4th, and you're in one of these counties, guess what? Landlord Tenant Act says you can't. It also actually gives a cap of 10% of the rent past due for the penalty. So if you're charging 11%, 15%, 20%, guess what? You're not following this. Security deposits, that's another big one here. It really outlines the whole process for what you need to do with a security deposit. There's a lot of protections around that for tenants. And so it specifies a process for charging their deposit and distributing their deposit. Specifically, it gives tenants the right to do a mutual inspection with the landlord upon move out to determine if there's going to be any charges against their deposit. So you got to follow this process if you're a landlord. Now, they have that right unless they do several specific things, and it lists them off here. Shall not have the right to inspect the premises if they've done any of the following: vacated the rental property without giving notice, abandoned the property, been judicially removed from the property, not contacted the landlord after the landlord's notice of right of mutual inspection, failed to appear at the arranged time of the inspection, or if the tenant has not requested a mutual inspection pursuant to this section. And so as a landlord, you need to offer them the right to inspect the property at move out if you want to have the power to charge their security deposit for any charges, unless they've done one of those things. Here's a real kicker in this section as well. The landlord shall not be entitled to retain any portion of the security deposit if the security deposit was not deposited in an account per this section. And the section says that tenant security deposits must be placed in an account used only for that purpose in a bank or lending institution subject to regulation by the state or any agency of the U.S. government. And so if you put a tenant security deposit in your own personal checking account, or you're mixing those funds with other funds, guess what? You've essentially just given up your right to charge the tenant security deposit for anything. So if you don't know something like this, that's a very easy mistake to make. If you just collect a tenant's deposit, put it in your bank account, and you worry about it later, you're making a big mistake there. Okay, here's a fun one. Looking at section 66-28-406, they define a service animal here. Service animal means a dog or miniature horse that has been individually trained to work or perform tasks for an individual with a disability. So fun fact there, they define a service animal as a dog or a miniature horse that has been individually trained to work or perform tasks for an individual with a disability. If you didn't know that, now you know. And of course, a tenant or a prospective tenant with a disability who requires a use of a service animal may request an exception to your pet policy. And so as a landlord, of course, you can't just go and deny a verified service animal. The Landlord Tenant Act also gives specific duties to landlords. They're kind of generic in general, but one of them, for example, is the landlord shall make all repairs and do whatever is necessary to put and keep the premises in a fit inhabitable condition. And so guess what? If the Landlord Tenant Act applies to you, you are kind of limited in your ability to maybe decline certain repairs if it means that the property is not in fit and habitable condition. Now, who gets to define that? Who knows? But use your own judgment on that. I mean, if the property is not habitable and maybe you as a landlord don't want to provide certain repairs, guess what? You're kind of obligated to. Here's another one in that same section. The landlord shall comply with the requirements of applicable building and housing codes materially affecting health and safety. And so you as the landlord are responsible then for knowing the building and housing codes. And so this is just another example of how there's a lot of complexity and complications that come with being a landlord sometimes. Something as simple as that requires you to be aware of not only this Landlord Tenant Act, but also these building and housing codes that could apply to you as well. Here's an interesting section on tenant abandonment. It actually describes what the process is if the tenant abandons your property. So if this isn't something you've come across or you aren't sure what to do if this happens, hopefully it never happens, but a tenant unexplained or extended absence from a premises for 30 days or more without payment of rent shall be evidence of abandonment. The landlord is then expressly authorized to re-enter and take possession of the premises. Well, that's important to know. If you haven't been receiving rent for 30 days and there's no explanation and there's an extended absence, guess what? It may mean that your tenant's officially abandoned the property and you may be able to just take that property back over, sounds like, without going through the eviction process or anything like that. Talk to your lawyer. The Landlord Tenant Act also describes what non-compliance means for a tenant, and it gives a list of things that are defined as non-compliance, and it gives the landlord some remedies what to do if your tenant is not compliant. There's more than just non-compliance for non-payment of rent. So if they stop paying rent, obviously they're not following your lease, but if they do certain other things, they may also be in breach of your lease as well. And if they do, you should know that you do have some options here. One specific example covers if the tenant is in non-compliance materially affecting health and safety. So specifically those things. If that's the case, a landlord can deliver a notice to a tenant specifying the acts constituting the breach of the lease and possibly have the right to terminate a lease for those reasons if they're not remedied. This section also describes the landlord's ability to file a detainer warrant immediately upon breach of a lease for failure to pay rent, assuming that the tenant has waived their right to a 14-day notice. Check your lease, see what your lease says, or if you're thinking about creating a lease, you might have a section in there that says the tenant's waived their right to a 14-day notice for non-payment of rent, and you may be able to immediately file for a detainer warrant to get your property, possession of your property back for non-payment of rent at least. These are just some random facts about the Landlord Tenant Act, stuff I'm just reading here. Again, applying to those counties with 75,000 in population or more. Here's an interesting section about one thing a landlord can't do to take possession of their property back. A landlord cannot recover or take possession of a dwelling unit, their dwelling unit, by action or otherwise, including taking away services or interrupting services, electric, gas, water, or essential services to the property. So unless in the case of abandonment, surrender, etc. And so you as the landlord apparently can't just go cutting off utilities to get the tenant out of there. This actually provides protection for the tenant in those instances. Another interesting fact in the Landlord Tenant Act is that the landlord has some obligations to provide essential services to a tenant. Those essential services are defined, and if a landlord does not provide those essential services, then the tenant actually has some remedies against the landlord for that. And so they define essential services here as utility services, including gas, heat, and electricity, and any other obligations imposed upon the landlord which may materially affect the health and safety of the tenant. And so if a landlord deliberately or negligently fails to supply those essential services, the tenant actually has some remedies against the landlord to recover some of those damages here. It actually also gives the tenant the ability to terminate a lease if the landlord is non-compliant with the lease. Some notices that have to be given. Each party has certain obligations, but I thought that was an interesting one because, you always hear about landlords having the ability to give tenants notices to vacate, eviction notice, etc. But if a landlord is not compliant with the lease and they're not giving the tenants essential services, they may also face some consequences as well, which is a less often talked about, probably a less often executed on scenario, but a scenario nonetheless that could be possible. So just another thing to be aware of there. Again, I just kind of skimmed through the Landlord Tenant Act. I wanted to highlight just a few key provisions that I thought were interesting or caught my eye. If you don't know, you should also be aware of the Landlord Tenant Act if you live in one of those counties, because that also could affect your rental property business. You can go through it and read the whole thing, and you should, but you should also consult with an attorney who specializes in that. Make sure your lease is in compliance with that. Make sure you understand your obligations, which if you're just using a generic lease online, this is probably where a lot of people may go wrong. You may not have the provisions that are in line with what the Landlord Tenant Act says you need to have. There's a lot of stuff in there that you may not have known as far as your obligations as a landlord, your processes you have to follow if a tenant's breaking the lease, etc. And so just want to highlight that, point that out. Make sure you check out the Tennessee Uniform Residential Landlord and Tenant Act. It's really essential if you're in one of these more populated counties and you have a rental property in Tennessee. Again, my name is John with Rent My Home Property Management company based in Clarksville, Tennessee, and we manage single family and small multifamily properties. Give us a shout if you have any questions, if you need help with your rental property, if there's something you'd like to go over, you want to talk about our lease, see how we can help you out. Check us out at TennesseeManager.com.